ready to start. I want to welcome you all and give a couple minutes for everyone to get situated. And I first want to thank everyone for joining us today and logging in for this very important webinar. I'm Vanessa Antone. I'm Senior Resource Counsel for the National Association of Criminal Defense Lawyers. And I just have a few preliminary housekeeping matters. I'll remind everybody as we start a webinar, as everyone's been accustomed to, this is being recorded, so please mute your microphone as we all listen to the presenters. And if you want to ask questions, we definitely encourage that. And we encourage you to use the chat function, which you can see in Teams, so you can send a question during the program and our presenters will answer it. You're on video, it's being recorded, so just be mindful of that. If for some reason you can't get the chat function to work for you, please feel free to email me directly, Vanessa Antone at NACDL. It's VANTOUN@nacdl.org. But chat is a good way to go. And I will also say that in the chat window, we have posted some resources to supplement this webinar, including the NACDL Task Force report that they will be discussing and additional resources, one from NAPD and an upcoming article from the Champion. In addition, a link to NACDL's coronavirus resource page. In addition to some of the materials being discussed today, it has a wealth of other resources. So that's some of my preliminary housekeeping matters. And now I will just check in with all of our speakers, see if you all are ready to go. Are we all good? So I will say thank you to all of our speakers today, and we are really privileged to have some experts on this topic, and I mean that sincerely. They are part of NACDL's task force on court reopening in the coronavirus COVID-19 era. So we have with us today Nita Ginsburg, NACDL's president and a lawyer in Alexandria, Virginia at DiMuro Ginsburg, and Nina works on many criminal matters, a variety of criminal matters, and especially in federal courts down in the Eastern District of Virginia, which is known as the Rocket Docket. Martín Sabelli is joining us from San Francisco, and he is NACDL's first vice president. I hope I got that. Martín, you can correct me if that's wrong. Martín has worked as a federal public defender, including as a director of training at the San Francisco office of the public defender, and he is now in private practice. So thank you for joining us, Martín. Todd Pugh is joining us from Chicago. Again, another one of our members of the board of directors. He's with Breen and Pugh there and litigates many criminal matters as well, and is an expert on returning to courts in the era of COVID-19. We have Stephen Ross Johnson, who, in addition to being a member of our faculty, will be our moderator. So thank you for doing that, Stephen. Stephen is in Knoxville, Tennessee, and he is not only on the NACDL board of directors, he has been president of our Tennessee affiliate, the Tennessee Association of Criminal Defense Attorneys, for, I think, 3 years, 3 terms. I might have gotten that wrong. You can correct me. But we are happy to have you all here. And now I'm going to turn it over to Stephen to kick off the discussion and to moderate. And just a reminder to everybody that we welcome your questions. And if you have any other questions for me, you can send them through the chat.
Thank you, Vanessa. Can you hear me okay?
Yeah, you sound great.
Great. Well, one point of clarification, I was president of our state affiliate. I was on our board here for 10 years and cycled up through the leadership chain, but I was only president for 1 year. I don't think they would put up with me for more than 1 year. So that's the only point of clarification I have. Thank you so much. This is a webinar that NACDL has put together to address something that is just at the forefront of everything that we are doing as criminal defense lawyers and really the tension between the criminal law system and the constitutional rights that we have to protect, and the health and safety concerns of everyone involved in the courts, including our clients and ourselves, as well as others. And so going into this webinar, right before it started, I checked with NACDL staff, and we have over 300 people registered for this webinar. And there are over 200 people registered who are not NACDL members. And so I would be remiss, because I am co-chair of NACDL's membership committee, to not say this. One of the great benefits of being a member of NACDL, and really to take a step back and tell you about NACDL, NACDL is the only organization in the country that represents both the private and the public criminal defense bar. We are the nation's criminal defense bar. And so when you see reports and resources like the report from the task force that we're getting ready to discuss and talk with everyone about, when you see those things coming out, really that could not be done absent the volunteer leadership and the members that NACDL has. And it's all the more reason why, if you are practicing in the area of criminal defense, you need to be a member of NACDL. We need you and you need us. So please, if you are not already a member of NACDL, and I know roughly 2/3 of you that have signed up for this seminar are not members of NACDL, please sign up and become a member of NACDL, particularly at this time right now. We need you and you need us. And so we are stronger together than we are apart. I'm going to turn it over to NACDL's president, Nita Ginsburg, and Nita is going to talk a bit about the task force and the work that we did and the report. Nita, you're muted.
Not a great way to start. Thanks, Stephen, and thank you for all of you for joining us. I'm really excited about this webinar because I just want to give you some background on the task force. But we started this task force, which is composed of Stephen, Martín, Todd, myself, and Norman Reamer, who's our executive director. I hope most, not all of you know, or at least know of. But we were, as an organization, inundated with requests for help from lawyers, members and non-members, who were being forced by judges to set trial dates in cases that had been put on hold because of the pandemic. Set trial dates for which the lawyers either felt they could not adequately prepare, or felt that put them and or their clients or their witnesses or clients' families at real risk to their personal health. And lawyers were calling and saying, what do we do? And what do we say to judges when they say we want to get our dockets moving? And how do we properly represent our clients and explain to courts what the risks, the health risks that we're all being posed with are really to all of us, and how do we balance those with the constitutional rights that are being threatened by all the limitations that the pandemic is placing on all of us. And as we started looking into this, all of the guidance that was being issued by courts and court administrators and legal groups related to sort of the practicalities. The federal judiciary issued a set of guidelines, I'm just looking at them, that talked about space preparation and arrival on jury, the day for jury service, and gathering jurors in safe environments and interactions with court personnel. But none of the guidance that was being issued talked about the right to confrontation and how do we preserve core fundamental rights to due process, and what do we do when we have a lawyer who feels that for personal health reasons it is a risk for him or her to appear in court, but you have a client who is incarcerated, not been released on bail, and asking for a speedy trial and wanting his speedy and public trial rights to be protected. And what do we say to judges when courts are recommending that jurors who ask to be excused because of COVID-related either health problems or economic problems, or courts are advising that these initial requests to be excused be granted without exception? And how do we assure that our clients are going to get a jury that's made up of a fair cross-section of the community? So what we were faced with is this inherent conflict between public safety and public health and the preservation of fundamental constitutional rights that were being jeopardized just because of the pandemic that we're all facing and the consequences of that. And we've taken the position, and I'm sure everybody who's on this webinar is here because they believe this, but that you can't compromise fundamental constitutional rights for the sake of public safety. And so we've tried to come up with a set of principles that takes into account the difference between civil and criminal trials, and that both gives weight to the individual needs of the lawyers and the clients who are the lawyers and the defendants in these cases, the need for some clients to have their cases moved because they are sitting in jail and have had no contact with their lawyers or with the court system, and how to make sure that their rights when they do go to trial are fully protected. So the task force felt that it was important to consult with some experts. We did consult with health and epidemiological experts. We talked with experts who had been examining juror responses. You have an article that Vanessa referred to on the impact on juries and what virtual trials might look like and how dangerous those can be for our clients. But also with the realization that for some defendants who need to move their cases forward, that may be the only option that they have. So we've established, or we came up with a set of 10 principles for going forward in criminal cases, and those are the ones we want to discuss today. We encourage all of your questions. We're learning more about this every day, so we'll probably learn from your questions about things that we haven't even considered and need to. But I'm just going to run through what these principles are quickly and then turn it over to the rest of the speakers to address these in more detail. But first is that in-person proceedings must be certified by independent medical experts to present minimal risk of COVID-19 transmission. Second, high-risk individuals should not be required to participate in in-court proceedings in which there is a risk of infection in the courthouse, nor should that person or the accused suffer any penalty or loss of rights for declining to participate. Third, any measures implemented to address the pandemic must be limited to the duration of the pandemic and tailored to meet an articulated public health need. Fourth, criminal proceedings require that conditions are restored that ensure defense counsel can meet their Sixth Amendment obligations, including the conditions necessary for robust, ethical attorney-client relationships. 5, criminal proceedings require that conditions are restored that ensure effective representation by conflict-free defense counsel. 6, constitutional rights must not be abridged. 7, the use of virtual mechanisms must be temporary, limited, and consistent with constitutional rights. 8, use of virtual mechanisms requires the informed and voluntary consent of the accused based on a robust attorney-client relationship. 9, any measures implemented to address the pandemic must not exacerbate the well-recognized historic failures of the criminal legal system. And 10, courts should use pretrial release and other mechanisms to minimize the pressures on the accused during the pandemic, including affording an accused the unilateral right to elect a bench trial where that trial right does not already exist. So those are the principles. I think Stephen's going to try and sort of group them into areas that have some commonality, and have our other participants start by giving their presentations on these principles. Again, thank you for participating. I hope you'll take Stephen's request that you consider joining NACDL seriously if you're not a member. This is the best organization that exists for criminal defense lawyers. It's really, in my opinion, the only one. People are here to help each other. That's what we do. That's what we will do. And I hope any of you who are not members will soon join us. Thank you.
Thank you, Nina. This is the part where I get to act like a talking head on television and really talk to a panel of experts. And so I'm going to moderate this discussion. We're going to start off by really talking about how these 10 core principles are grouped into particular categories. And so if you look at the task force report, and it's on NACDL's website, if you go to nacdl.org, coronavirus resources is prominently featured on the website. You can click on those resources and you can immediately get access to the report. And so I'm going to turn first to Todd Pugh. And Todd, in the report at page 6, we begin to group these categories, these core principles together. And principles 1, 2, and 3 concern how reopening must be based on science. It must be made under independent medical supervision and must be limited to the duration of the pandemic. I guess fundamental to all of this is having some understanding of the science. And do you mind just talking about those core principles and talking about the science with respect to COVID-19?
Thanks, Stephen. Absolutely. And let me start by saying, despite what Vanessa said, I am not an expert. And when Nina gave us this assignment, we're going back about 8 weeks now. And when I looked back through my emails and the discussions that were happening between Martín, you, Stephen, President Ginsburg, and our executive director. The landscape as lawyers that we were looking at that time is the same as the rest of you who are on this call. New York was in absolute crisis mode. The emergency rooms there were not enough beds. The death toll was mounting every single day. But across the country, we were receiving calls from lawyers who were being compelled to answer ready for trial under circumstances that were less than ideal, and that the data that we were receiving at the time as to this virus was incredibly uneven and inconsistent. And when the 5 of us sat down, one of the things I think we all concluded at that time is that we were anything but experts. We were lawyers who knew enough to be dangerous. And fortunately, one of the first things our executive director did was to tap into the preeminent medical experts at Stanford University. Martín and I were able to tap into some resources at Northwestern University and to begin our discussion with the first principle, which was that any measure designed for reopening courts, and this discussion is probably going to mostly focus on jury trials. I think by now we've all been doing our status hearings by telephone and Zoom and things, and Martín's going to talk about what the impact that has had on the attorney-client relationship in a little bit. But we're primarily talking about jury trials. And the greatest concern that we had at that point in time, which I think all of you have, is that judges were making a decision about what was to be safe, what was to be appropriate in terms of reopening courthouses for adversarial proceedings. And that's why our very first principle that we have that's been published is that any measures designed for reopening must be based upon independent medical supervision. And as practitioners, we believe that this is a question that every lawyer should be asking when they are moved to proceed to any type of adversarial proceeding on behalf of our clients, is that the measures that the local courthouse is employing, that these measures have been vetted by scientific individuals. We all know that this virus has been politicized, and that just because the local political structure has said it's okay for restaurants to be open, it's okay for people to not wear masks, does that mean that what the local political structure has advocated would be okay inside of a courtroom? And the things that we learned first when we started our research on this was, the first question is, how is this disease spread? And the data then and the scientific evidence is that it is better to be outdoors than indoors, and that this virus is easily spread through person-to-person human transmission in enclosed spaces under circumstances where individuals are speaking, the transmittal of breath in rooms that are poorly ventilated, and everything that the scientists said about how the coronavirus is spread is exactly as a courtroom is. And because of that, we took the position that based upon the scientific evidence, there was no way for jury trials to proceed, and there does not appear to be any way right now for jury trials to proceed in a manner that all of us have become accustomed to. And most of the courts have echoed that and have implemented some type of prophylactic measures to try to protect public health while at the same time trying to protect constitutional rights. The other issue that we had that we felt was very important is that individuals who are, by CDC guidelines and other medical guidelines, are designated as high risk should be allowed to be excluded from any participation in any type of adversarial hearing. And that goes just as much for the attorneys as it does our clients, as any other participants in the judicial process. For instance, individuals over a certain age, 65 and older, we all know that today are persons at risk. Persons with pre-existing medical conditions are at risk. But the area that we actually found, which is a very important area to remember, is that any individuals who live with persons or are primary caretakers to persons at risk, they must necessarily be excluded without penalty. And we began our discussions about, well, how might it work for a client who has counsel of choice, and that counsel is being pushed to go forward in some type of adversarial hearing, and that counsel, for instance, is at risk for contracting the coronavirus and therefore needs to continue the matter. And the court says, well, it's not going to grant a continuance. So we have this, as Nina already said, these inherent conflict. We have these conflicts of rights, and these are everything as practitioners we need to be mindful of. And a lot of the things we discussed about, and the reason that we need to get our hands around all this is object, object, object. And the objections that we're going to be making and that we are making on behalf of other lawyers, on behalf of our clients, these are not typical objections that we learn throughout our years of practice. This is all very different issues. The other thing is something to remember, that if the community at large has instituted certain procedures and the courthouse adopts those procedures, the community at large, or the political structure at large, they are instituting these procedures for political and economic reasons. And we all know that. Again, which is why our first principle is that these must be for under independent medical supervision, and always beware docket management. I just received an email this morning from a case that was continued because of the jury trial was to begin July 7th. It has now been continued by court order. But I received an email that the judge would like to know when the parties would be ready to try this case, and has encouraged us that we do so sometime between August and November. And yet we wake up this morning and we read the news this morning and we learn that it is predicted that 180,000 Americans will die by October 1st because of this virus. We learn that as of 2 days ago, New York, New Jersey, and Connecticut are imposing travel restrictions. And much differently than when we started this project, all of a sudden the South and the West are being impacted by this virus in a way that didn't appear to be so when we began this project 7 weeks ago. So the sands of scientific evidence are changing every single day. And if some county medical official signs off on some courthouse procedures 4 or 5 weeks ago, those same procedures may not be deemed safe today. So as practitioners, we really need to pay attention to this. And the final aspect of the first 3 principles, and I think that this is the most important in my opinion, at least for lawyers. About 10 weeks ago, when Cook County was struggling with how to keep the dockets moving with the courtrooms doors locked, I had a discussion with the with our public defender. And as she was working with the chief judge in the sheriff's office, her greatest concern was, and I think everybody on this call will think about this same concern, it is axiomatic that judges and prosecutors and courtroom personnel love it that our clients are not going to court right now, that they can just be placed in front of a camera and zoomed into their status hearings, to their plea hearings, in certain cases, into contested pre-trial matters. And that the ground that we give now for purposes of creating a safe environment for the public, a lot of these stakeholders in the criminal justice system will want to make these permanent. And that's why one of our most important guiding principles in this report is that any measures adopted to keep people safe in light of the virus, that these are temporary and that they must be narrowly tailored to address a specific medical concern. I know where I am, we used to do video bond hearings, and a lot of you on this call probably are in jurisdictions where bail hearings are done by video. They were removed from Cook County about a decade ago after a study showed that that bail amounts were much higher when an individual appeared through teleconference as opposed to being live in front of the judge. And Cook County got rid of it. Well, they're back now. And I see that as a new horizon for a fight for all of us as practitioners, that some of these methods of necessity will become methods of convenience, and that judges, prosecutors, and jailers are going to take the position that they never want to bring our clients to court anymore. So that's why that's the third component of this first set of guiding principles. And I have some other things to share later on, but at this point in time, we would open it up to any questions, or we can just continue to move on with the principles.
Thank you, Todd. One question that I have for you, and I'll throw out to Nita and Martín as well, is, we all are dealing with, and you touched on the fact that there are things that we have been forced into doing, sometimes because out of necessity to move our client's case along, or it's a situation where we feel like it's in the best interest of our client to move forward in some sort of remote proceeding in some way. And with the CARES Act, the federal courts got a lot of additional money for teleconferencing capabilities, video conferencing capabilities. And so that technology is going to remain in the federal courts, and our state courts are doing the same things. And so what can we do? What do you suggest we do? I pose this to all three of you to help ensure us as the criminal defense bar that we don't lose ground, and that when the pandemic is over, we don't end up in a situation really where, out of convenience, our clients are not present physically in the courtrooms. Who wants to take that?
Nina, do you want to?
I'll start. I'll start off. I think there are a number of answers to that. One, and I think it probably the best armor that we have, at least in the short run, is to point out to courts that that want to conduct these virtual proceedings is that the CARES Act allows virtual proceedings, but only with the consent of the defendant. And I think that we have to be vigilant in making sure that courts go through a meaningful colloquy with our clients, that we make sure to put representations on the record. If you haven't been able to adequately meet with your client and explain what the consequences of a virtual proceeding could be on their case, it varies with the type of hearing or proceeding that you're having, but it's certainly much worse if you're having a hearing where credibility is an issue, or you want the judge to be making a personal connection with your client. But most of us can't go into our local jails because of restrictions on visitation. Talking with our clients is difficult. Continuing to maintain a meaningful attorney-client relationship can be very difficult, and putting that kind of information on the record and objecting to going forward either with a waiver when you don't feel that you've had an adequate opportunity to make sure your client knows what he or she is waiving, I think is important. And making these records is critical. There are judges who are talking about getting defendants to just sign blanket waivers at the beginning of a case to have remote proceedings throughout their cases. No one should ever agree to do that. I just think that we have to start thinking in terms of what these proceedings, how they interfere with our clients' rights, and how do we make sure that we are objecting in ways that are preserving our records in cases where we don't think that they should go forward.
May I add one thing to that, Stephen?
Absolutely. And Martín, we cannot see anything other than the top of your head right now.
Oh, really?
Yes.
That's so funny. How about now?
Yes, now we can see you.
Okay, well, that phone's going to fall. That's very funny. Good. Well, I agree with what Nina said, obviously, and most of what I want to say about this subject will be related to the fourth and fifth principles that I think we're going to be discussing in a moment, so I won't say much. Just want to add one tiny drop to Nina's excellent exposition, and that is that one way to look at what's happening here is to put it in the frame of an election of rights issue, of a compelled result, and that's problematic. And so if your client is being compelled to elect between rights, that is a frame and a concept that is very useful because it taps into a body of case law, and it just makes plain sort of horse sense that if your client is making a certain election in the context of having to give up other rights, that's inherently problematic. And so preserving that as part of the record, I think, is extremely important. And you'll see that theme in our report. It's a theme that we tried to pull out in the report because many of the choices our clients are making, particularly those who are subject to being in custody during the COVID crisis, where they're risking their health and their life, or the health and life of anybody who is able to visit them for whatever reason, or who they see when they get out. Those folks are really between a rock and a hard place. And conveying that to a court, making a record on that within the frame of an election of rights, I think is extremely useful.
Thank you. Thank you, Martín. Thank you, Nina. And along those same lines, I mean, I have if you go to the coronavirus resources page on NACDL's website, there are examples of filings at trial court levels that address these issues where, if you want to make a record about this. And for example, my motions that I have filed in cases that are at the pretrial stage where I have clients who are in custody, I put it in my written motion, the reason why we can't go to trial right now, the reason why I need a continuance, the reason why I can't even file pretrial motions, and it's because the lack of the ability to exercise the complete defense function, which, as we all know, is so much more out of the court than in the court, which is a great segue to you, Martín. with principles 4 and 5. And in the report at page 8, principles 4 and 5 are discussed in the heading of measures designed to facilitate reopening cannot be implemented unless conditions are restored for defense counsel to fulfill their Sixth Amendment functions. Can you explain that? What does that mean?
Sure. I mean, what you just asked, you've just answered, and it fits right in with what Todd said. We're not really experts. We have put together ideas and thoughts and concepts that all of us know within the framework of responding to this particular pandemic. And principles 4 and 5 have to do with the fact that courts are trying to jawbone or shoehorn trials in a context, in a societal context in which it's almost impossible to do our work. And so what principles 4 and 5 do is look at what's happening from a constitutional point of view and an ethics point of view. And essentially our point with principles 4 and 5, which are closely interrelated, is that if you're trying to explore how to work things out within the courtroom to try to make things work, how does an attorney speak to a client confidentially during trial and all that sort of thing, don't forget that the attorney to be there and doing the right thing in the right way, meeting constitutional and ethical standards, virtually impossible to do it in the context that we're living in right now. It was hard enough pre-pandemic to represent people, hard enough pre-pandemic to represent people who were in custody, hard enough in many situations because of social, economic, racial differences, accesses to jail, all sorts of things to construct attorney-client relationships of trust, caseloads, mandatory minimums, of course, of plea bargaining. All of that made it very hard to develop relationships of trust and do the work we needed to do. It's a lot harder right now. It's very hard to meet our ethical standards. It's very hard to meet our constitutional Strickland standards. And why is that? Because it's really impossible to get to the jails. It's impossible to hand documents or other physical things to your clients and sit with them and develop the relationship that you need to work with them. Therefore, it's tough to get the information you need to investigate. You can't even send your investigator in the field in the same way. And even if you could, he or she is going to get the door slammed in their face quite often because nobody wants to be talking to somebody they don't know. So in other words, and we can go into it much more deeply, but principles 4 and 5 remind the courts that whatever you're trying to do to make it okay in the courtroom, it ain't okay if the lawyers cannot be representing our clients, but up to ethical standards, meeting ethical standards and constitutional standards outside the courtroom. And what principles 4 and 5 try to do with citations to ethical standards and other standards is to remind us of that really fundamental fact. I do a lot of work in Argentina in reforming their jury trial system, which has just started, even though it's in the Constitution 3 times from 150 years ago. And what's happened is immediately courts are doing exactly what Todd said and saying, this is great. We don't even have to have, those people, our clients, in the courtroom. And they're trying to do exactly what Todd said, and that is to make jury trials as costless as possible, as effortless as possible, by eliminating all of the issues all the rights that we know that make them function. And outside of the courtroom, that means we have to be able to meet with our clients, meet with witnesses, go over discovery. Our clients need to be able to go over discovery alone as well. We need to be able to investigate, send investigators out, and do all of that constitutionally required and ethical work. And that's principles 4 and 5. And if you ask me, that's what courts really need to be reminded of most, because they don't have that personal experience for the most part, even if they have criminal experience, because most of those folks were prosecutors.
Steve, can I usurp your role for a second? I wanted to ask Martín a question based on a question.
Nita, that's part of the privilege of being president. So
somebody asked, I saw in the chat, asked a really good question, and it goes right to this the question of our ethical responsibilities to our client. I think the question was asked by someone who is probably a public defender or takes court-appointed cases, but asked what, and it doesn't just apply, I think it applies to lawyers across the board, but what do you do if you have a client that wants to go forward, but you feel that you are at personal risk for high risk for the virus, that you can't adequately represent your client without putting yourself at personal risk, and in fact maybe even creating a conflict between you and your client? What are your ethical responsibilities under those circumstances, and what should you do in the courtroom?
It's an excellent question, and it's one that is addressed, engaged really by our principles, and that is this notion that in order to proceed in this context, we need to be able to provide conflict-free representation. And where our interest in going forward with the trial does not align with our clients, that is, our clients want to go forward and we have an age issue, a comorbidity issue that makes us concerned, very concerned about going forward, that can rise to the level of being a conflict. And individual lawyers will have to evaluate that. There are situations in which lawyers and clients are aligned and moving to continue, and situations where clients want to continue, sometimes because of this election of rights deal, where they're very afraid of being in a COVID-infested jail, and the lawyer doesn't want to go forward because of fear of comorbidity. The lawyer also might have concerns about the constitutionality of the trial, which he or she can discuss with the client. But just in terms of the client's own personal safety concerns for himself or herself, or for their families who might be infected, there's a serious potential for conflict. And if that occurs, that is something that needs to be brought to the court's attention and needs to be litigated. And in certain situations, courts may follow or may respect the lawyer's position. And in other cases, people will be ordered to proceed and will have to decide whether or not to comply. If you're an NACDL member, the strike force, NACDL's Lawyers Assistance Strikes Force, has intervened in cases like that. It's a difficult situation to be in. It's hard enough to be a criminal defense attorney given the infrastructure that we work in and the context we work in. This makes it really, really hard, in particular where you're feeling that you're taking a position that your client doesn't want you to take. All I can say is it's a really tough position. If you're an NACDL member, we have got your back on this thing. And so let us know.
Thank you, Martín. And thank you, Nita. Martín, along these principles 4 and 5, because they are so critical to what our role is, it's so critical to the defense function, right? That we have to perform outside of courts. And I agree with you. I think that this is what courts really are not getting, and we've got to get it across to them that all the outside courtroom things that we have to do to satisfy the defense function. How effective do you think, or how do we deal with courts that would respond to that and say that, well, we've instituted policies with our local jails where they're not going to charge your clients to call you on the phone, or they're not going to charge you to have an iPad video conference with the client. As we all know, so many of us deal with clients that are in custody in local county jails. The big movement now in local county jails is to get rid of any in-person communication with people from the outside. And so even family members are communicating or having visitation, and their only method of visitation with the client is via video that they pay, $5 a minute for, which is insane. But how do you respond, Martín, to a court saying, well, we've conferred with the sheriff, we've conferred with the detention facility, you can sign up for unlimited video visitations with your client on an iPad, and so you can perform the defense function and obtain a meaningful attorney-client relationship in that way. How do you respond to that? What's your response to that, Martín?
Well, I've got 3 things to say to that. First of all, within the context of a particular case, you got to make your record. And I'm a firm proponent of never waste any crisis. And this is a crisis where you can try to turn that around and say, okay, Your Honor, you're saying this. Let's be clear. I represent an MS-13 member from El Salvador who doesn't know how to read and write, and you know, and I don't speak the language, and I do speak Spanish, but even if I do, there's still a separation, and you can really make a record to start educating the judge, but you have to, and coerce it. You know, if there's a plea bargain for 10 years on the table, if you're in federal court with some mandatory minimum, you can make the record about all sorts of things that are happening to your client, and the impossibility of having the right kind of relationship and the right kind of interaction with your client. That's number one. So make that record and use it as a way to educate the judge about the particular issues of the case and the larger context. Number two, you got to do it outside the courtroom. Get working groups together that are going to educate the bench about this, because sometimes in the context of a particular case, you're going to lose if you're doing it on the fly. But if you're doing it with a little bit more room, with other lawyers who have your back, and with more time and consideration, you might be able to push the bench as a whole a little bit further. And finally, right now, with what's going on around the country, all of the racial justice issues that are happening right now, we're going to come to some of the racial justice implications towards the end of today, because those are principles 9 and 10. A lot of the energy around responding to courts pressuring lawyers, which was really, really high before, is justifiably, and I'm I'm very happy about this, is going into racial justice issues. So some of the wind that was in our sails 9 weeks ago, when the four of us were working on this with Norman, has gone out of our sails, because a lot of activists are focused, legal activists are focused on the racial justice issues. And that is as it should be, in my view. But that just means we're going to have to work a little harder within the context of our cases to make those records.
Steve, can I add something?
Absolutely.
One of the things that I've found to be very effective, and you have to know your judges, your local bench, but many of us, probably most of us, have been practicing long enough to at least have, if not friends who are sitting on the bench, at least judges on the bench who we know well enough that we can communicate with. And a lot of judges really are at a loss of what to do, and they appreciate getting information. And so I have made it sort of a practice of, any time I come across something helpful that I think a judge should read, like our principles, like the NAPD statement on virtual court proceedings, like articles, like I found one again today. First Hennepin County jury trial since pandemic results in quarantine for judge and staff. I send these to my friends who are on the bench, and they most of the time get back to me and say thank you, and I'm circulating it to the other judges, and they're actually appreciative, and it gets them thinking about things that they otherwise wouldn't have thought about, because as somebody on the chats is saying, that most of the judges are reaching out to civil practitioners for advice and suggestions about what to do. So to the extent that we can take advantage of our relationships with the bench in our communities, that's something we ought to do. And then the other end of that is, we all have to look at ourselves and decide, if it comes to it, are we willing to risk contempt if we're forced to go forward in a case that we just feel either ethically we can't perform our obligations, or our clients are not being provided with their, constitutionally fair trials. NACDL has been asked to provide strike force assistance to some lawyers who have felt that they could be in that jeopardy. Fortunately, that hasn't happened yet, and I'm not encouraging people to be held in contempt, but that is a possibility. And if that happens, you should reach out for help.
I think somehow we've got someone sharing their screen.
Yes, someone has started sharing their screen, so
We can see
I
your
will-
emails, please.
Susan Thompson, we can see your screen if you can unshare it, please.
Yes. They can do. Is there a way for us to take control of that?
I just requested control, so hopefully,
I think
I
you're
think
back.
okay,
Went away. We're back. We're
Okay.
back. So it's what, well, you know, once again, gosh, that's a great example of the dangers of this technology and trying to master this technology while you're having a hearing, and trying to conduct court proceedings in that way. One thing that I would suggest is that we all need to resist the temptation to engage in shortcuts with the attorney-client relationship. I have had lawyers tell me that, oh my gosh, I love being able to just communicate with my client via video in jail. I don't have to go out to the jail. I don't have to talk to them in this way. It's a lot more efficient. And so some of that is, I think, well-intentioned, but just not thought through. And I would suggest that we need to, as we talk about courts resisting the convenience of technology like this, that we need to think through those things as well with respect to what we do. And just to echo what Nina said about really engaging in a dialogue and communication with policymakers like judges. Tim Zarillo, who is a member of our NACDL membership committee, and when this report was issued, several members of our membership committee were interfacing with folks on the ground, with our local affiliates and others. And Tim sent it to a federal judge in Maine. Tim is in Maine. And the federal judge in Maine, where he is, said, oh my gosh, this is wonderful. I'm putting you on the courts task force so you can help us formulate what our policy is going to be concerning courts and jury trials. And so just to emphasize what Nina said, I think we all need to be, as the criminal defense bar, engaged with our courts as they are trying to put together policies and they are searching for answers. Todd, I'm going to turn back to you, and principles 6, 7, and 8 in the report are grouped together at page 9, and they talk about measures designed to facilitate reopening must not abridge fundamental constitutional, statutory, or customary rights. Now, that is really broad. And can you explain what's the report talking about there?
It's the coolest section of the report, Stephen, for us as lawyers, because this is where we are experts. And this is where all of us who are approaching these issues are uniquely equipped to view every single mechanism that a court is offering to move their docket along through the prism of constitutionality. And I would expect that the experiences of those of us who are on the task force and other people we have surveyed will be as varied as all of yours as we look across the country. As Nina mentioned, we're trying to do a great job of keeping up on what type of mechanisms are being employed in other jurisdictions and some of the negative consequences that are coming out of those experiences, sharing them with members of the judiciary in our jurisdictions, and as Stephen also indicated, getting it out through the affiliates so that your individual bar associations can be sharing this information and getting these guiding constitutional principles into the hands of your presiding judges. Now, make no mistake, we know this. There is never going to be a way to completely reconcile protecting public health and protecting the constitutional rights of our clients. That is one of the conclusions that we came to in this report. Well, one of the reminders that I make to everybody, and the citations are contained in this report, is that both the Department of Justice and the NAPD and the American Bar Association have all quoted the United States Supreme Court in that just because there's a crisis, and I'll quote actually Justice Scalia, it hurts me to do this, but it's contained within the NAPD report, is that we're not free to conduct cost-benefit analysis of clear and explicit constitutional guarantees and then adjust their meaning to comport with our findings. And what that means for all of us as practitioners, and what we've concluded to, is that our clients' constitutional rights come first. The fact that there is a pandemic, the fact that there is a danger out there to jurors, to lawyers, to members, anybody participating in the legal process, does not mean that our clients' constitutional rights take a back seat. And when I was looking earlier, I did look at some of the questions that were coming through. And I believe a practitioner who's I think they said they're appointed counsel in perhaps Ohio, said that they are an at-risk attorney and that they're being compelled to proceed to a jury trial under circumstances that would put their own health at risk, and ask the question whether or not they should just withdraw from representation in that case. Well, and I say no, and I think the task force is in agreement to this, is that our clients have an unfettered right to counsel. And that right to counsel includes the right to counsel of choosing. And if the lawyer who our clients have chosen to represent him or her is particularly vulnerable to contraction of this illness and can't do their job ethically under the circumstances, then the court must make the accommodation for the lawyer and not place this need to move the trial along first. One of the components of this constitutional rights section really focuses on these virtual mechanisms. And I will be honest with you, I practice in a jurisdiction that up until 14 weeks ago, virtual mechanisms were almost non-existent in the criminal division. They have now become commonplace. But to echo what we had in the first section is these virtual mechanisms that have allowed our clients to appear in court via closed circuit television, that these are to be temporary as well. That this is not the new way of doing things. And all of the attorneys that I've worked with on this, as well as the attorneys we have surveyed, have all said the following, and I would welcome comments from the participants in this. Our relationships with our clients, particularly those clients who are in custody, have suffered over the past 14 weeks since the closures. It is incredibly important, as we came together to write this report, that we spend time with our clients, that we appear next to them in court, that we bond with them, particularly in appointed circumstances where there's always a certain sense of distrust. And that any of these mechanisms that are put in place now, as Stephen had said, was, oh, it's great, lawyers are saying, I don't have to go to the jail anymore. Trust me, I've been doing this for 25 years. No lawyer likes to go through the jail, to go through the humiliation of the search and leaving your medal behind. And that aspect, as much as I love to visit my clients and spend time with my clients who are in custody, the measures that jails place upon us as attorneys is certainly nothing that any of us are a fan of. And we have to make sure that anything that's been put in place now, because I have not been able to, as most of you have not been able to have live visits in a custodial settings with our clients, that phone calls and Zoom calls are not a replacement and never will be a replacement. And that any time any of our clients choose to participate in any way in a proceeding virtually, I think Nina mentioned this already earlier, is that it must be done with the client's consent. And that is consistent with our principles. It's also consistent with the NAPD position paper. But along with that, we can't have an infirm attorney-client relationship and be counseling our client to sign off on a waiver to participate in some type of proceeding virtually. For instance, I have engaged in some agreed upon sentencing hearings virtually. But the NAPD takes the position, and I think our position as well, is that a contested sentencing hearing should never occur virtually. So I know we're getting deep in time, but I'm going to throw out just a couple of things that I think Martín will pick up on. And for instance, we kind of broke this down. Our constitutional rights. Martín already mentioned this. Our Sixth Amendment obligations to our client includes the includes that we must fully investigate our clients' claims and defenses. Very difficult to do under the current circumstances. Our ability to consult with our clients has suffered. Big question that comes right now, and this just actually dropped minutes before this, is what are jury pools going to look like? What will jury pools look like? I'll just share with you a couple statistics about 50% of individuals surveyed, and this is going to be posted hopefully shortly. More than 50% of persons surveyed would find it difficult to give a trial their full attention under these circumstances. And that nearly half of those persons surveyed have suffered household income losses and would find it difficult to spend time on any type of jury trial of a certain length. And the particular impact, and I'll let Martín pick up on this, has been on women and communities of color. What does that mean for us? It means that most of our juries are going to be the type of people that are don't think the virus is all BS and they don't need to wear a mask and they can get together for a hot tub party in the Ozarks and not suffer any type of consequences. A couple things about in trial. A lot of courts in this area are advocating jury trials wearing masks. And in our article that we put out, we rely heavily on Mr. Dubin's research on this, is that between 35% of communication is nonverbal. We need to remember that when you're allowing a witness to testify with a mask, you're allowing jurors to be questioned and voir dire with a mask, you're losing 35% of the communication. We also looked at a couple of other things as well. Proximity affects empathy. That is an absolute fact. And when they do these large spread out courtrooms where the jury is far away and spread out from each other, and the defendant in those cases is wearing a mask, how does that affect a jury's ability to empathize with our clients? And finally, one of the things that was actually quite interesting, as Martín and I met with some of the jury consultants and looking at their data, was jurors who were potential jurors who were surveyed said that they were 2/3 of them were unwilling to engage in a trial where deliberations would last more than a day. And what does that mean? That means for us, rushes to judgment. Our clients appearing via telepresence, according to scientific studies, is that our clients are less humanized. And we can't allow that to happen as practitioners. As I mentioned a little bit earlier, the study by the University of Chicago showed that defendants appearing via teleconference routinely received more draconian bail amounts and bail conditions than persons who presented themselves live. So as practitioners, these are all of the areas that we need to be, as Martín said, make a record, make a record, make a record.
Thank you, Todd. Just in the interest of time, I mean, we could stay on that topic for hours, right? Because we have all been forced into hearings of some sort that were something less than what any founder would have ever thought a court proceeding would be. But in the interest of time, I am going to turn to principles 9 and 10, and Martín, you to really address those and talk about those, and talk about those in the report. And those principles, are combined under the heading on page 12. Measures designed to facilitate reopening must not exacerbate the historic failures of the criminal legal system. And address that for us, Martín.
Sure. First of all, we were really hip and cool in calling it the criminal legal system and not the criminal justice system. That shows that we're in touch with young people. So we should pat ourselves on the back on that. We're in touch with the young people. The point of principles 9 and 10 is something we've addressed today already, but it really is fundamental, and that is we are in the process of a profound transformation of a system that people across the political and social spectrum have agreed has failed us. Some people call it broken. Some people say it's working the way it was intended to. But either way, there is a broad social and political consensus that the modern American criminal legal system has failed us. And that has been addressed in a number of ways. For example, NACDL's trial penalty report focused on coercive plea bargaining practices, focused on one historic failure. There are other profound historic failures that we're talking about every day now that have to do with race and class and other forms of discrimination, from the school to prison pipeline, to policing practices, to prosecuting practices, to what happens in the courtroom with jury selection and all sorts of other things. And what Principles 9 and 10 attempt to do is to approach the current issue about trials and proceedings in the age of COVID with a focus on this transformation that we were proceeding through, and pointing out that given the directions in which courts have been moving and some of the practices that prosecutors have been moving towards, there is a real risk that what is going on now will have a profound and negative, disparate impact on people who belong to vulnerable groups in our society. And so there are certain things we can try to do about that. For example, lessen the use of pretrial detention. One way to minimize, and in some cases eliminate, this tension between your right to be safe and your right to go to trial is to liberalize pretrial release the way pretrial release was supposed to be. That is to reverse the overuse of pretrial detention that has characterized our system. Another specific measure that could be used in the short term rather than the long term is the unilateral waiver of a jury right trial, informed, of course, and that information, that informed consent based upon a real attorney-client relationship, so that somebody can say, look, I want to go to trial, but I don't think I can get the fair kind of jury in this context. So I unilaterally waive that right without needing the prosecution to do it. And so what Principles 9 and 10 attempt to do is to remind us, which we already knew about, that we were in an era of profound transformation supported by all sectors of our society, and that COVID has and risks interrupting that really positive transformation, and that we should be aware of that and be very focused on trying to minimize the impact on vulnerable communities, in particular communities of color, who are going to be hit hardest by this, by the lack of attorney-client relationships in appointed cases, and by all sorts of other issues. So what 9 and 10 attempt to do is to get us back on the moral arc of the universe the way we were going before the pandemic started.
Thank you, Martín. And I'm going to plug, based on something you just said, I'm going to plug NACDL's website and the coronavirus resources page again. Pretrial release, as you were just talking about, some of these issues are not as difficult if people are not in custody awaiting trial. And there are some components of the attorney-client relationship and review of discovery and other things that can be facilitated more easily when people are not in jail in the middle of a pandemic. If you go to the coronavirus resources page of NACDL, there are examples of filings that have been made for people seeking pretrial release, to include interlocutory appeals to the circuit courts of appeals federally for pretrial release, based on not only your client's susceptibility to being at risk for serious illness from exposure to COVID-19, but also the inability for counsel to perform the defense function because of this. And so it kind of goes back to what Todd and Nita and Martín have been saying about, we have to make a record of these things and to make certain that we get them before the courts.
Stephen, can I really
yes,
really strong emphasis here? on the danger that coercive plea bargaining practices, whether it's through charge bargaining or other mechanisms, is really going to be exacerbated here, because you have clients who are vulnerable. They don't have the same kinds of relationships. They're not confident, therefore, in their attorneys. They don't have the trial mind. They don't know if their attorneys have the trial mind. Investigation is hard to accomplish. So you get the police file, but you can't do your own investigation in the same way. And so clients are going to be scared. And when they're scared and sort of unattached from their lawyers, the power that coercive plea bargaining, prosecution coercive plea bargaining tactics have is magnified. And we have to be aware of that. We have to resist that. We have to call that out. That was already a huge problem as the NACDL trial penalty report pointed out. And that is now going to be much greater risk to the rights of our clients. So we need to be vigilant about that. And courts have a funny view about that. I had a discussion with the judge the other day about setting a trial, and I used these arguments to try to get a solo trial in a federal RICO case. And the judge came back, and this is not an unintelligent point. He's a very bright judge and a good person fundamentally. Well, so what about all the jurors I have to call in for multiple trials? The other clients are out of custody. You want this solo trial, but now I'm going to have to, if I do what you want me to do, Mr. Sabelli, I'll have to have a series of trials rather than 2 or 3 or whatever. I'll have to have double the number of trials. So there are specific arguments we have to be ready to address and bring our clients' interests above those, particularly where our clients are vulnerable populations.
Thank you. And Todd or Nina, before we get to audience questions, is there anything that you want to add concerning those comments on Principles 9 or 10, or anything else for that matter it's in the report?
Yeah, I just to follow up on Martín's point about vulnerable populations, I think that is a concern. And the use of virtual technology and remote proceedings poses maybe a greater, or certainly a different, but probably a greater danger certainly for our clients who are in custody, but also for people who are going to be appearing remotely, who are in communities of color that don't have good access to computers, to broadband technology, to environments where if they're going to appear remotely, the backgrounds are going to be, in some instances, perhaps demeaning. They're not going to have the same kind of decorum that people who appear in courtrooms or in law offices have. And those things are going to create credibility issues, not only for jurors, but even for judges who are making credibility assessments. And so it's I think so important for us to just be cognizant of all of the aspects of the kinds of alternative procedures that are being used by courts and how they impact different communities differently. I've had a couple of remote hearings where the witnesses, their connections kept breaking up. They couldn't figure out the technology. One case, a judge just got so impatient, just canceled the rest of the hearing. And, there are just, there are so many pitfalls, and we just have to be constantly on guard to make, feel like I sound like a broken record, but to make a record and to make objections so that people are as protected as they can be in these kind of situations.
I'm going to throw out a few audience questions to our panel. And we had one question from an audience member. It says, are you aware of a jury trial in North Texas, the subject of a federal public defender webinar yesterday? Are you all aware of that? And what's your what's your understanding of that and how that trial was conducted, and with respect to the principles that NACDL has? Who wants to take that?
Well, I can say something about it. I know that was litigated aggressively by the federal defenders in terms of not going to trial, of believing that the conditions were unfair. There was an acquittal. There was a not guilty. You gotta respect, right? And under those conditions, there was also an acquittal last Friday in a capital case. Michael Ogle, a longtime public defender in California, delayed his retirement 2 years, took a case to trial, a death penalty case, and walked the guy. Also an acquittal. So, it's not entirely clear. Some people have speculated that juries couldn't really come to consensus and be unanimous because of these divisions, and there's some thought about that there might be more hung juries, but those trials both resulted in not guilties. In Michael's case, it was a resumption of a trial, and they thought it was going well, so they didn't really press the mistrial. In the Texas case, they tried very hard and were forced to go to trial, and did. I don't know what the procedures were like in the courtroom, but that certainly was resisted as strongly as it could be.
I have some audience questions that people are posting.
Oh, can I say one more thing about that?
Absolutely, Martín, go ahead.
There are motions, and I don't think they were done in the Texas case, but I know of some federal lawyers in Colorado who are moving early on for a discovery of the court's procedures and protocols for jury trials during COVID. And I did the same thing in a federal RICO case this week, and I understand that in my particular context, there is no public health certification, no public health work done to ensure that the courtroom was a safe courtroom. And what would that mean? That would mean an infectious disease expert, possibly, an epidemiologist, possibly, and then somebody who knows about airflows, an environmental expert who can say, you got these plexiglass up, but it doesn't matter because after a short period of time, there's going to be enough droplets in the air that it's going to go over every barrier in there. So these are things you can and should move to discover before you're anywhere near trial.
Thank you. I believe that you can. We've got a little bit of time left, and so you can post your comments or your questions in the meeting chat function. You can also hit at the dialog box at the bottom of your window for this. You can hit the function that says raise your hand. And so we had someone raise their hand just a moment ago. I believe it was Ardina Garth. And Ardina, do you want to, you may have put your hand up and then put it down. Do you still want to pose your question to the panel? Ardina she's gone. Or she's quiet now. She put her hand down. So with respect to some of the comments, we have someone who just asked, they said that they're someone who is a journalist who was formerly incarcerated, and that this person sees the downside certainly to having video hearings, but poses the question to us of what about the situation though of if you're someone who is in custody. It's one thing to be shipped to the courtroom in a paddy wagon or in a transport bus for trial, for a hearing of substance. But what if have to be transported just for routine short matters or short hearings, and you're at risk for contracting COVID because you're in the same paddy wagon that goes and arrests people and picks them up, and is not being cleaned and is a COVID factory. And so that's part of this inherent tension. And what comments do you all have about that?
I'll say this. I can say this just because I mean, I'm happy to cede to Nina or Todd, or you, Stephen, but the reality is there are some ways that video conferencing can be useful. And we should be open and explore that, but it is not in lieu of in-person appearances. And video conferencing in terms of meeting with our clients can be useful, but only when you already have a constructed attorney-client relationship of trust. And so, yeah, we're going to have to watch out for our clients. Here in California, they were setting up video conferences in a way that was risking the clients by passing tablets or putting a client in a small room right after another client had been in the small room. So video conferencing isn't necessarily safe either. So it underscores the need to preserve our attorney-client relationships, preserve the in-court functions like in-person cross-examination, presence in, let's say a Daubert hearing or an expert hearing before trial, and also to make sure that whatever video conferencing is set up for the meeting with our clients is not instead of person-to-person contact, and it's safe, because video conferencing is not necessarily safe.
I'll share this, Stephen. I mean, my clients who are in custody, who are appearing in court, are appearing in a room at the jail with a deputy sheriff standing behind them, wearing a mask, and are asked by the judge, Mr. So-and-so, are you here today? I can tell you that the judicial officer's view and attention that he or she is giving to that client is zero, and that the relationship that is developed between that client and his or her lawyer is zero under those circumstances. However, I will say for many criminal defendants who no longer have not certainly been going to court lately, who are on bail or on electronic home detention or on some type of work release, it's been a great function of them not having to appear. They haven't had to take a day off work. They haven't had to pay to park at the courthouse. So there are some upsides to at-risk communities about not necessarily having to show up every 30 days. That is a huge cost for a lot of people to have to show up for a status hearing and sit in a courtroom for 4 hours until their case gets called, simply to just get another date. So there's a big cost that comes with this. So I think there's good that can come out of all this, but we as practitioners must be mindful that no bad come out of this.
Yeah, I think also that we have to, where possible, try and convince judges that there are procedures that can be used that mitigate some of these dangers, and try and do that before the hearings happen. I mean, a lot of times the judges, their clerks will call you and say, this is what how the judge is going to do it, and these are the instructions, and you'll get a text to log on, and sometimes you do practice sessions with the clerk. But if you know that you're going to have a client that is going to be in a room and there's going to be someone from the sheriff's department standing behind him, you could ask the court to do something to make sure that the person you're representing is in a room where you can have a confidential chat with them through the video program, or so that there's some way you can talk to them without having a deputy sheriff standing over their shoulder. If you think that you might need to communicate with your client in the middle of this hearing, bring that up ahead of time. Don't just sit there and wait for it to happen and then find out that you needed to ask your client something in the middle of the hearing, or your client blurts out. I mean, I had a hearing where my client kept saying, "Can I say something? Can I say something?" And the judge kept saying, "You might not want to do that." And I kept saying, "Judge, can you give me a few minutes?" And actually what ended up happening, the judge he left the room, the prosecutor left the room where the video equipment was. I had a chance to speak with my client, and then he actually did address the judge. But it's hard enough to be a lawyer, and then when you have to manage all these other things that are related to the video proceedings, and how you introduce an exhibit, and how do you prevent your client from blurting something out, it's really incumbent on us to plan ahead of time what you think could happen and what kinds of, things you might ask the judge ahead of time to allow you to do to facilitate the best possible hearing that you can get.
And I'll throw in there that, something that you touched on, Todd, about, someone coming in every 30 days for a status hearing and having to take off work and sitting in court for 4 hours. And, all of us have experienced something like that. And I think the upside to this is that, to quote Martín again, let's not waste a crisis. The upside of this is that we can cause courts to rethink some of the inherent docket management procedures that they were using before the pandemic. How efficient is it to make people come in every 30 days and sit in a courtroom for 4 hours? And when you think about certain populations that have jobs where they can't do that, or childcare issues and other things like that. And so Martín, the takeaway from what you were saying is, I think that, and to get to what our participant was questioning us about, is that these procedures, meeting with clients via video or video hearings, as long as we take reasonable measures to ensure confidentiality with those, they can be used to enhance an already existing robust attorney-client relationship, but they should never be in lieu of that attorney-client relationship.
Yes, and there are budgetary reasons that courts will want to do that, particularly in light of the pandemic, the effects of the pandemia on the economy. Municipal and local budgets and state budgets are going to be slashed, so there's going to be a lot of pressure on courts to try to minimize some of those things, and we have to stand up to that. Here's an alternative, though. Here's a budget-saving thing, and in a way, and I raise this as kind of a banner towards the end of our talk. And Todd and I had a disagreement about this as we wrote this. We're both in line in terms of what we want, but our disagreement is about whether or not this is going to happen. And that is, we all think, hey, judges are now looking at pretrial detention differently. They're understanding, because of compassionate release mechanisms and other pretrial litigation now, that they should let a lot more people out on pretrial release. And the hope that I have is that will translate also into less time, less custody time at the sentencing phase as well, because I think we can make a good argument based upon everything that's happened with compassionate release and the overcrowdings of jails and the knowledge now about poor health in jails and about the conditions in state and jails and prisons, that judges ought to take better looks at how they exercise their discretion in terms of sentencing. So one aspect of not wasting this crisis, and it's not my phrase, I think I stole it from Rahm Emanuel, and I don't know who he stole it from, is that we ought to be reminding judges about what we've learned during this crisis, this pandemic, to lower sentences. Sorry, I was getting a call there.
It's all right. Well, we'll still attribute the quote to you because possession is 9/10 of the law, and you possess it on this call. So we are out of time, and I'm going to turn it back over to Vanessa with NACDL. But I just want to really say thank you so much to Nina and Martín and Todd and talking with us today and talking about the task force report, and also to all of you that got on yet another video call that we are all subjected to in today's world to talk about these things that are so important to us. And I'm going to remind you one more time that we need you in the criminal defense community. NACDL needs you, and you need NACDL. So if you're not a member of NACDL, you have seen a little bit of what we're about in this call. So please join us. Vanessa.
Thank you, Stephen. I can't say it much better than that, except to thank all of our great presenters today for engaging in the discussion with the NACDL members. So thank you to NACDL's president, Nina Ginsburg, Todd Pugh, Martín Sabelli, and Stephen Ross Johnson, our moderator. Thank you all so much, and thank you to all of you for watching. If there are materials or other things that were mentioned that you aren't able to get access to in the chat or don't find on the website, feel free to shoot me a direct message and we will get those to you. Again, NACDL thanks you and encourages you to check out all the coronavirus resources on our page and use those to better assist your clients. Thanks, everybody.
Thank you, everyone.
Thank
You
you. Bye-bye.